Constitution sufficiently protected individual rights and promoted the common good? What responsibilities, if any, do citizens have for seeing that individuals' rights are protected and the common good is promoted? Gary.
Alright, sorry. Federalist 46 states, the accumulation of all power, legislative, executive, and judiciary, in the same hands may justly pre-pronounce the very definition of tyranny. To combat tyranny and protect individual rights and promote the common good, the Constitution outlined a system of checks and balances, separating the powers of government to prevent tyrannical consolidation.
The Constitution separates the legislative, executive, and judicial powers of the national government into 3 branches. Each branch's power serves as a check on the other branches, and in line with Federalist 46, the powers of each branch do not overlap. For example, the Supreme Court decision in Prince v. U.S. prohibited the legislative branch from functioning as the executive as well, citing Article 2, Section 1. It ruled that interim provisions of the Brady-Hangen Act were unconstitutional. The provisions impermissibly allowed Congress to require state officers to execute federal law.
Separation of power is also achieved by balancing federal power with state power. This dual sovereignty advances local control, which promotes the common good, exemplified by the prosperity of the colonies during salutary neglect. Maintenance of control helps prevent the situation that led to the revolution in the first place. Britain's strong government overpowered the sovereignty of local colony governments, leading to oppression through legislation, such as the Sugar, Stamp, and Tea Acts.
To limit national power, Congress is denied many powers in Article 1, Section 9, especially the suspension of habeas corpus and the passage of bills of attainder or ex post facto laws. States, in addition to Congress, are also denied the powers of ex post facto laws and bills of attainder in Article 1, Section 9. These limitations protect individual rights to due process. They promote the common good by protecting the public as a whole from arbitrary government. These limitations were not in place in Spain during the reign of the Spanish Inquisition, and as a result, Spain's citizens and economy suffered terribly.
States are checked against each other. Article 4, Section 2 mandates that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states, which, as the Supreme Court ruled in Paul v. Virginia, inhibits discriminating legislation against the citizens of each state by other states. Thus, this clause limits state power and protects individual rights from discrimination based on state citizenship.
The nation-spanning republic outlined by the Constitution was a source of disagreement between the Federalists and Anti-Federalists. In favor of the large republic, Federalist 10 argued, a republic promises the cure for the violence of faction, and that, the smaller the society, the more easily will a majority execute their plans of oppression. Anti-Federalists thought that such a large republic would not protect the common good because the rulers would not be acquainted with the interests of many citizens and so could not represent them properly.
Federalists contended that individual rights could be inferred from the body of the Constitution, habeas corpus in Article 1, Section 9, trial by a jury of peers in Article 3, Section 2, and freedom of religion in Article 6, Clause 3. Anti-Federalists, especially George Mason, argued that interference was not sufficient and instead wanted enumeration. Thomas Jefferson stated, "A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on interfering."
To protect their own rights and promote the common good, citizens must be active. If the government is abusing its power, citizens have a responsibility to vote for new leadership. Only by being complacent can citizens become subject to tyranny. Franklin Roosevelt noted that nobody will ever deprive the American people of the right to vote except the American people themselves. And the only way they could do this is by not voting. Citizens are also responsible to protect their rights, everyone's well-being, by using their First Amendment rights to free speech, press, peacefully assemble, and petition for a redress of grievances. Active citizenship to protect individual rights and the common good was displayed during July 2014 in Ferguson, Missouri, when many citizens exercised their rights to free speech, press, and peacefully assemble in response to the alleged police brutality and the infringement upon the freedom of the press. Thank you.
Were the founders and the framers, either one, really that fearful of a strong central government?
The Federalists saw it as necessary. The Anti-Federalists were very wary of a strong central government because being under the rule of tyrannical Britain, but Federalists saw the importance in a strong central government.
I think the reason for the Anti-Federalists being more on the fearful side was that they were, in general, more less affluent, more rural, and they were closer to the people. So the framers themselves, as a whole, really felt that a strong central government was necessary. That's why there was the convention in the first place, but the citizens or the people of the United States under the Articles of Confederation were afraid of it, and the Anti-Federalists were just a little closer to them.
I'm gonna interject on that. Has anything changed? Is it still the rural who's fearful of the strong national government and the urban who want a strong national government?
There's certainly a case for that. And Cliven Bundy down in the boondocks, he really hates the BLM and the national government, and he's got a whole little militia going up against them. So, yes, I think that's a very valid point. Just continued.
Was the Bill of Rights necessary?
The Bill of Rights was necessary because the Anti-Federalists wanted their rights specifically stated, and without adding a Bill of Rights, the Constitution would have never been ratified.
Yeah, although we do see individual rights such as habeas corpus and the right to, Congress can't make bills of attainder ex post facto laws, there are a lot of things such as freedom, like First Amendment rights such as freedom of speech and peacefully assemble and all that stuff that isn't in the actual Constitution.
The Bill of Rights is also important and necessary through the incorporation doctrine, which enforces states to adopt the Bill of Rights so that state constitutions have to protect those rights.
How does that exist?
Well, that was started by Gitlow v. New York in 1925.
No, it wasn't.
1897 was the first
No, it
case,
wasn't.
but Barron v. Baltimore
Okay, great.
said that it wasn't incorporated, but the incorporation happened either in 1897 or
No, it didn't.
1925
No, it didn't. It happened in 1865.
by
The 14th Amendment,
well,
which is what creates the doctrine of incorporation.
the
That's your part of this.
okay. Well, 1925 Gitlow v. New York incorporated freedom of speech to the states. Well, just to go back to the previous question, the Bill of Rights was also important because it set a precedent for the process of amending the Constitution, and it set out the idea that it was possible to amend the Constitution. That was very important because there have been many important amendments, such as the 14th, that have been passed as a result of that process.
Okay, so I don't know, branching off my question then, like the Constitution, does the Bill of Rights limit government power to protect individual rights while also promoting the common good?
Yes, we see this in the 10th Amendment because it gives states who are closer to the people all the rights not previously stated in the Constitution.
The first 5 words of the Bill of Rights, well, in the First Amendment, say Congress shall make no law, and that's a total limitation on government power right there. And those definitely protect individual rights, like freedom of speech. That's an individual right. But these are also important in protecting the common good as well, because the due process amendments, and amendments 4, 5, and 6, they protect the common good by ensuring that the government does not become completely arbitrary and just detain people and not even prosecute them, just give them a sentence without any sort of process of law.
Can Congress create rights?
Congress can make laws that means that the government can't infringe upon certain rights or the government has to protect certain rights, but they can't necessarily create rights.
Why not?
Because rights, or natural rights,
They
is
are.
What?
They are?
As John Locke states, it's life, liberty, and property.
I'm
So
Native American, I don't believe in property.
okay, so life and liberty, and yeah, the pursuit of happiness.
Thanks, Jefferson.
But it's something that most people would say rights are something that are God-given. It's not
I don't
something.
believe in God.
Well,
Okay. Well, okay. That's what I just said. Some people would say.
I believe in several gods, not just one.
As Learned Hand said, the Constitution, and the rights that come with it, exist in the hearts of men or women. So it's important to note that I completely agree with Molly. The Congress can make laws that respect those rights, but the rights exist there just because we exist.
Has the Constitution stayed current enough through the amendment process to limit the government and also protect the people today?
I would say yes. There's a series of checks and balances that are very important so that one branch of government can't overpower another branch.
The Supreme Court, I guess I should start out with, as our society progresses and more issues come up, it's the Supreme Court's job to rule if something's constitutional or not constitutional, and that's a major check on what's going on in our nation. And that's, with the amendment process, is something that can keep the Constitution relevant.
Can I say something? Or no?
Go ahead, keep going.
I want to disagree with my colleagues because I don't think the Constitution itself gave the opportunity for that. While I do agree that the Supreme Court has done a job of making sure that the Constitution stays current and the interpretation is apropos to the times, the fact that the Supreme Court interprets the Constitution and the constitutionality of laws is not in the Constitution. So, yeah, the Constitution itself doesn't do that. It was the precedent set by Marbury v. Madison in each of the three.
And so, how does the Constitution balance powers between the federal and the state level, and how does this work towards protecting individual rights?
Well, the first thing I would say is that the Constitution itself limits both the federal government and the state governments. Article 1, Section 9 places limits on Congress, which is the national part, but Article 1, Section 10 is the same for states. And while the sections aren't exactly the same, they have many of the same protections in there, like protections of habeas corpus and protection against bills of attainder and ex post facto laws. And so that is a balance. The state can't do something that the national government can't do, at least in those situations. So that helps promote individual rights to due process. And
It also butts heads a little bit because the 10th Amendment states that all powers not delegated in the Constitution are reserved to the states and the people. However, the Supremacy Clause states that the national government makes laws of the land in the Necessary and Proper Clause. So it is very opposing it.